Understanding the Insurrection Act, its purpose and authority. The Insurrection Act of 1807 is a significant United States federal law. It grants the President of the United States special and quite serious powers. Under this act, the President has the authority to deploy the U.S. Armed Forces for domestic law enforcement purposes. This means soldiers can act somewhat like police officers within the country's borders. This law has been in place for over 2 centuries, designed for situations where normal civilian law enforcement is insufficient to handle a crisis. The core idea is to provide a powerful tool for restoring order or enforcing federal law when absolutely necessary. Understanding its provisions is crucial for appreciating its impact on American life. Normally, the United States military is prohibited from engaging in domestic law enforcement activities. This principle is primarily upheld by the Posse Comitatus Act. The Posse Comitatus Act generally forbids the use of the U.S. Army and Air Force, and by extension the Navy and Marine Corps, through Department of Defense policy for civilian policing. However, the Insurrection Act carves out specific exceptions to this fundamental rule. It allows the President to override the restrictions of Posse Comitatus under carefully defined circumstances. This exception is not meant for minor disturbances, but for truly extraordinary situations where the fabric of law and order is threatened. There are specific conditions under which the President can invoke the Insurrection Act. One common way is at the request of a state's legislature or its governor if the legislature cannot convene. This typically happens when a state faces widespread domestic violence, an insurrection, or a conspiracy that its own forces, including the National Guard in state status, cannot control. The state government essentially asks the federal government for military assistance because its resources are overwhelmed. This pathway emphasizes cooperation between state and federal authorities, though the ultimate decision rests with the President. The President also possesses the authority to invoke the act unilaterally, without a request from the state. This can occur if the President determines that an insurrection, domestic violence, or a conspiracy is hindering the execution of federal laws to such an extent that it's impracticable to enforce them through ordinary means. Furthermore, it can be invoked if such actions obstruct justice or deprive a segment of the population of their constitutional rights, and state authorities are unable or unwilling to protect those rights. This unilateral power is particularly potent and has been the subject of much debate and concern regarding its potential scope. Concerns and potential misuse, a delicate balance of power. A primary concern surrounding the Insurrection Act is the considerable power it vests in the President. The Act grants broad discretion to determine when a situation warrants the deployment of federal troops for domestic law enforcement. This means a single individual, the President, holds the authority to make a decision with profound implications for civil liberties and the traditional separation of military and civilian spheres. The interpretation of terms like insurrection, domestic violence, or what constitutes an obstruction to the execution of the laws can be subjective. This subjectivity worries many who fear the power could be used inappropriately or for political ends. Adding to these concerns is the fact that the Insurrection Act contains few explicit and robust legal checks on the President's authority. The language of the statute is more than 2 centuries old and, in some areas, lacks the precision one might expect for such a powerful tool. Historically, federal courts have shown considerable deference to the President's judgment when the Act has been invoked. This judicial reluctance to closely scrutinize or overturn a President's decision means that a key mechanism of oversight within the U.S. system of checks and balances is less effective in this context. This leaves the door open for potential overreach. Recent history has brought these concerns into sharper focus. For instance, there were multiple reports that former President Donald Trump considered invoking the Insurrection Act on several occasions. One notable instance was during the widespread protests against police brutality and racial injustice in the summer of 2020. Another reported consideration was in connection with efforts to challenge the results of the 2020 presidential election. These discussions, even if they did not lead to an invocation, triggered significant alarm among legal scholars, civil rights advocates, and the general public about the potential for misuse. These episodes have amplified fears that a future president might be tempted to deploy the military under the act for reasons that fall short of its intended purpose. For example, a president could potentially use it to suppress peaceful protests with which their administration disagrees, thereby chilling free speech and assembly. There are also concerns that the act could be used to intimidate voters, particularly in contentious election periods, or in a worst-case scenario, to interfere with the lawful and orderly transfer of power. Such actions would represent a grave threat to democratic norms and the fundamental rights of citizens. Recommended actions if invoked roles for everyone. If the Insurrection Act is invoked, it is critical for the public to take specific actions. Firstly, individuals should prioritize staying informed through credible, fact-based news sources, avoiding misinformation. It's advisable to document any observed events, particularly the conduct of military personnel, using photos or videos if safe and legal to do so. Citizens should actively contact their elected representatives at all levels, local, state, and federal, to express their views, demand transparency, and call for accountability. Supporting non-partisan civil liberties organizations that work to protect constitutional rights also becomes especially important during such times. Understanding one's constitutional rights is paramount, especially if confronted by military personnel acting in a law enforcement capacity. These rights include the right to remain silent and the right to legal counsel. While peaceful assembly and protest are cherished American freedoms, individuals should be acutely aware of the heightened risks and potential for escalation when the military is deployed domestically. Acting calmly, responsibly, and with a clear understanding of one's rights can help ensure personal safety and uphold democratic principles, even in a challenging and potentially volatile environment. Knowledge empowers individuals to navigate such situations more effectively. State and local officials also have distinct and vital roles. If these officials believe that the President's invocation of the Act is unlawful, unnecessary, or an overreach of federal power, they can consider several courses of action. They might publicly denounce the deployment, clearly articulating their reasons and concerns to their constituents and the nation. They can explore legal challenges to the invocation in court, although, as noted, the judiciary has often deferred to presidential discretion in these matters. Governors can also play a crucial role by potentially refusing to consent to the federalization of their state's National Guard units if the president attempts to do so under certain provisions of the Act. Military personnel themselves face a profoundly challenging ethical and legal situation if the Insurrection Act is invoked. They are bound by their oath to obey lawful orders from their chain of command. However, they also have a fundamental duty enshrined in military law and ethics to disobey orders that are patently unlawful. Military leaders bear a heavy responsibility to ensure that all service members are thoroughly educated on their legal obligations, the specific rules for the use of force in domestic operations, and the imperative to safeguard the constitutional rights of all Americans. This careful balance is essential to maintaining the military's integrity. Historical context, safeguards, and proposed reforms. Throughout American history, the Insurrection Act has been invoked relatively sparingly. It is generally viewed as a measure of last resort, intended for only the most extraordinary circumstances, where civil order has collapsed and state and local authorities are demonstrably unable to cope with the crisis. The infrequent use of the Act underscores its serious nature and the significant implications it carries for the balance of power between federal and state governments, as well as for individual liberties. Each potential or actual invocation prompts considerable public debate and legal scrutiny, reflecting its profound impact. There are several notable historical instances where the Insurrection Act was utilized. In 1957, President Dwight D. Eisenhower deployed elements of the 101st Airborne Division to Little Rock, Arkansas. This action was taken to enforce federal court orders for the desegregation of Central High School in the face of significant state and local resistance. More recently, in 1992, President George H.W. Bush invoked the act to deploy federal troops to Los Angeles to help quell widespread rioting and restore order following the acquittal of police officers in the Rodney King beating case. These examples illustrate its use for both enforcing federal law and restoring civil order. Regarding existing safeguards against potential misuse, the Insurrection Act itself contains few explicit legal constraints on presidential power. As previously mentioned, the judiciary has historically adopted a stance of reluctance when it comes to reviewing the president's decision to deploy troops under the Act. This judicial deference means that the primary restraints are often political rather than strictly legal. Public opinion, congressional oversight, and the internal advice given to a president by legal counsel and military advisors play significant roles in shaping whether and how the act might be used, making these informal checks critically important. Recognizing these limited safeguards and the potential for abuse, organizations such as the Brennan Center for Justice, where I work, have advocated for specific reforms to the Insurrection Act. Proposed changes include requiring the president to consult meaningfully with Congress before invoking the act and mandating a detailed, specific factual basis for any such invocation. Other suggestions involve imposing clear time limits on troop deployments, clarifying the permissible scope of military activities during domestic operations, and, crucially, strengthening the avenues for judicial review to ensure that presidential decisions are subject to more robust legal scrutiny. These reforms aim to better protect against misuse of this powerful law.